Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillah, walhamdulillah, wa salatu wa salam ala rasulillah. Jazakallah khairan, Brother Hishem Alsalman, for joining us and being willing to give us a basic seminar on the legal process of preparing last will and testament. I want to make one clarification because I've gotten questions from the community on this. Some of you may have attended the workshop that we had in December with Mufti Atif regarding in the Sharia, Wasiya wa Riwatha, the will and inheritance. This presentation has more to do with the legal process of filing your will here in the state of Kentucky. MashaAllah, Brother Hishem is taking this time out of his day to give this informative seminar. The intended audience is for those who may have heard of, okay, last will, last testament, estate planning. I don't know what that is, right? Especially here in the United States, here in the state of Kentucky. So, Jazakallah khairan again, Brother Hishem, for being willing to give us such an informative seminar. Shukran.
Thank you guys for having me. Assalamu alaikum. So my name is Hishem Alsalman. I'm the founder of Alsalman Law Office. As Hamza said, today I'm going to talk to you guys about just some of the basics regarding estate planning and will preparation and what that entails. And just as a brief disclaimer, I just wanted to make sure to notify you guys that this presentation is just touching on the basic principles of estate planning and it's drafting wills. I would highly recommend reaching out to some form of legal professional or tax or an accounting individual that can assist you with this. So the first thing is, I just want to go over what is the problem, right? Not having an estate plan or a will can lead to significant issues, and that basically leads to, family disruption over asset distribution, uncertainty in guardianship with the ones that you love afterwards, and it can just lead to a lot of tax consequences and undue delay for your family. And so, when we think about it, there's a lot of us out here that potentially don't have a will or some form of estate plan after we pass. And that can create a lot of legal complexities for your family, especially in their time of grief. I've had relatives in the past that have passed away without a will, and some of their cases are still pending today. And so it creates a very, very complex process for them. And so, you may ask yourself, what is an estate? What is estate planning, and who needs one? Well, we highly recommend that everyone has an estate plan of some sort. If you have some, if you're over the age of 18, having some form of estate plan is very, very important because it assists you with managing your finances, preparing for retirement, ensuring a smooth transition if you have a business or anything valued. And the biggest thing is if you think about what will happen with your family after if you unfortunately pass away, then this is where creating a will and setting up some form of estate plan will assist you. And so what comprises your estate? So those are, intangible and tangible assets. So it can be anywhere in the ballpark of, your house, car, your jewelry, personal possessions. But then there's also the intangible assets, where if some of you all are business owners, you also have that. That is part of the process. You also have stocks, bonds, cryptocurrency, bank accounts. All these different items are what comprise a full estate itself. And so when you're creating an estate plan, the main goals and objectives is to maintain control over your estate and protect your spouse and your children and your loved ones and prevent any delays in the process because it can be very, very lengthy if you pass away without a will or some form of estate plan. Your family has to deal with a lot of court, and then court gets to depict on how everything is transitioned over to your family. It also, the estate plan also provides a protection for your family against creditors. That's one thing a lot of people forget about is creditors, and so it also helps your family, reduce the estate taxes and income taxes. And so, what are some of those typical planning documents? You have, like as Hamza mentioned, the last will and testament, which is basically your will that says what happens to your assets afterwards. And we'll go over each one of these, briefly. So, the next one is a trust. I know some of you may have heard of a trust. That kind of sometimes provides the highest level of protection for your assets. Then you also have financial and medical power of attorneys. Those can help your family. It helps basically make decisions for you in case of some form of incapacity to you. And then there's a living will as well as appointment of guardianships, and we can talk about these further. So what is a will? So a will basically serves as a legal document that outlines how a person's assets and possessions should be distributed upon their death. Now, I just put just a couple brief definitions up there. So a testator is basically the individual that creates the will, creates and executes the will. You have the executor, who is going to be the person that's appointed to take care of the will and make sure to carry out the wishes of the will for the testator. Then the beneficiaries are usually, your spouses or children and loved ones that you include in the will. So, what is the primary purpose of a will? So, it's, as we mentioned earlier, asset distribution, guardianship for minor children, for those of you that have children, as well as executor appointment. And so, asset distribution, in that will, it will basically discuss and provide clear instructions as to what happens to each one of your tangible and intangible assets after your passing. Now, the guardianship for minor children, that allows people, when you have children, if God forbid something happens to you and your spouse, well then, who's going to be the one that takes care of your children? And that's where a guardianship, preparing something for guardianship is very, very helpful. The next one is as executor appointment. So the executor is going to be the person that's going to be handling your estate and making sure and carrying out your wishes in the will and passing those items correctly, working directly with the court and your attorney and everything else. So, as well as the accountant. And usually a lot of people like to appoint like a sibling or a close friend to be their executor to kind of handle that part. The fourth thing that we say is it minimizes family disputes. There's often times where, loved one passes away and now there's many disputes as to who's getting what or what's going to happen. And it can create a lot of complex family issues. If you already have a will, you can't really, go against the will unless there's something that can discredit that will itself. And then there's tax planning. If you want to devise some form of property to your nephew or your niece or someone else, creating a full estate plan and then put it in the will can actually help minimize potential taxes. And the most important thing is it allows you all a peace of mind, right? So by creating a will, it allows you to know that your wishes are going to be carried out in the manner that you want them to be carried out in. And that your loved ones are going to be taken care of just based upon what your personal wishes are. So some of the basic requirements of a will is you have to be at least 18 years old to create a will. You have to be, the testator must be of sound mind. That just means that basically you understand what you're creating and what you are, you understand personally as to, there's no medical incapacitation. You're able to understand what you are doing and how you are distributing assets in that will. Signature by the person creating the will. And then witnesses. Usually there are 2 witnesses that can sign off with the will. And then a will in Kentucky must be written of some form. Some of them you can write it out, but it's preferably typed out so that it can be fully legible. And then it designates some form of beneficiaries. So beneficiary, like I mentioned earlier, is basically who's going to get what in the will. So those are your spouses, children, family, loved ones. And so what is included in a will? So it's some of the basic principles are, it's obviously personal information, your personal address, and then the person that you're going to designate to be the executor that's going to carry out the will and distribute your assets in the manner that you wish to have them distributed, as well as assist in, with court and attorneys and tax and accountants. Now the guardianship for minors, like I mentioned earlier, you can put a clause in there where if something, God forbid, happened, like I said, to you and your spouse, you can designate that your sister could be a loved one that can potentially take care of your kids, or a brother, or anyone, a close friend, family, anyone that you want them to potentially be able to take care of your kids, especially if they're minors. Then we also have asset distribution, and as I mentioned, so that's basically, what happens to your car, what happens to your house, what happens to any different property that you own. And then specific requests, sometimes people like to give one thing that they built together with a friend, they like to give that specific item to a friend because they want to carry on a specific legacy, or there's specific indications like that they know someone's going to take care of the next thing for them. And to carry on, so there's a residual estate clause in there, and what that basically means is whatever that is not listed in the will specifically, and that is if you, for example, you create a will tomorrow and you put all the different assets you have, but in a month from now, you buy a new car, you buy a new house, you buy something else that you didn't specifically mention in your will, well, the residuary clause basically gives that person who you designate the remaining part of the assets in your estate, and so they get everything else that's left. Some people like to designate that as a spouse or some form of child or a friend or a loved one. The other thing is when we think about that, sometimes we forget about how's our burial going to be taken care of, who's going to pay for that, what are those expenses. And so through your will, you can designate how those procedures are going to be carried out, who's going to take care of the debts, right? So a lot of us, if you own a house, you potentially have a mortgage. If you don't, that's phenomenal. And we need to talk about trust for you, but we'll go into that further later. But so with debt, what happens to that debt? What happens to any car loans? If you finance the car or if you lease the car, right? What happens to your assets and what happens to the debt after you pass? And then, like I said earlier, witness signatures. But the main thing I want to make sure that everyone is aware of is self-proven affidavit. So there's specific legal terminology in Kentucky that you have to include in a will. And if you include that specific terminology, it basically makes the will a self-proving will. And that is, you don't need to bring one witness to court with you to say, hey, this is a valid will. No, it's because you follow the specific legal terminology that says, hey, look, this will is actually the legitimate, full, final will of that individual. And unless someone comes in and says, hey, no, he updated the will, and here's the most recent one, then that would alone stand on its own as a valid will, and you don't need any witnesses to come and testify on behalf of that will. So I would strongly suggest if you create a will to make sure you include that in there. It's optional, but it's highly recommended. And then obviously the date and signature of the testator, which basically the one creating the will. And that's just to show when this will was executed. Most of the time, a lawyer or accountant or someone that is creating a will can assist you with that. So from a legal professional. And to go further a little bit into proving a will, as I mentioned earlier, so to establish the validity of the will in court, it requires you to produce the original will itself. That means that you can't, if I created a will today and I went and photocopied it, that's not original. No, you have to have the physical original. And that's why oftentimes when you work with a lawyer, they like to create multiple different copies so that you can potentially save one with yourself, the lawyer can save one, you can give another one to your executor or your beneficiaries to keep with them, and so then that way they have the actual original will. Because if you don't have the original will, they're going to presume that you don't have a will. But most of the time, courts can work with it to some extent, but it's still not a valid will at the end of the day. And that's where I mentioned earlier the self-proven approved will. So those wills, you have to have it notarized. You have to have a specific terminology according to Kentucky's statute. And you have to have 2 witnesses signing that they saw you sign this document. And then, so then that way, self-approved will basically, it'll be accepted in probate without any witness having to testify on your behalf in court. And actually, I was working on one of those not too long ago, and the judge didn't object or say anything, they give us any issues because it was a self-approved will. It already validated itself. So, now the next thing to think about too is, I know, I'm going to create a will today, right? But what about, like I mentioned earlier, I'm going to buy a new property and maybe a year from now, I'm going to buy another car, buy stocks, whatever it is, buy a new business. So then what happens, how often, should you update that will? Well, we recommend revisiting the will every 5 to 10 years, just to kind of give you a little bit of time and perspective as to, maybe there's new statutes, new laws, just kind of revisit, maybe someone, passed away, or that you had designated in your will, or maybe your executor, something happened to them, or, as I mentioned up there, a major life event. Maybe you get married, maybe you get divorced, unfortunately. Maybe you have another child. Maybe there's major changes in your finances. Or as I mentioned earlier, just the death of a beneficiary in the will. So that way you can keep it updated and keep it current so that, it doesn't, because what happens is if you provide someone's name in a will as a beneficiary, but they pass away, then that piece of property that potentially you gave to them now falls into the residuary estate, part of the estate. And so the remaining person can get that. But you can set up clauses where you can designate, if this person gets it and they have a child, then the child gets it, and so on and so forth. You can, draft it how you would like to make sure it fits your personal needs. And so the next thing I want to touch upon is just, I want to briefly touch on what is the trust, what is the medical power of attorney, financial power of attorney, and then, living will, which is really, really important to consider and think about as well. Because if there are 3 words today that you should, take home is a will, a trust, which trusts are very, very complex, and we'd have to be able to, talk about that a little bit more. Maybe we could provide a seminar about that in the future. And then living wills. So what is a trust? It's a legal arrangement where a person, who is known as the grantor, transfers assets to a trustee who manages and distributes them to beneficiaries according to the terms specified in the trust document. And this may provide the highest level of protection of asset distribution, and it provides a major shelter from creditors. So this is also, if you're one of the individuals that, so if there's an individual that has maybe paid off house or some form of paid off properties, you want to consider potentially a trust, just because if you want to talk about generational wealth, trusts may be able to assist you in that, and it protects your family and that specific asset from creditors. Now, as I mentioned earlier, so the financial power of attorney, that is a legal document that grants someone, an agent or an attorney, or the executor that you can designate as a friend or whoever you want, the authority to make financial decisions on your behalf in case, in the event that you are incapacitated, you become incapacitated where you're not able to, mentally function anymore. You can't make any more financial decisions. So that person would be a trusted individual. It could be a friend, it could be a spouse that can make financial decisions on your behalf. And then the next one is similar to the financial power of attorney, is the medical power of attorney. So, there's going to be a time where, it might be a time where medically you become incapacitated. They need to make decisions as to what happens with you now. When is it time? What do you need to do to take care of your well-being? And so by designating someone, a trusted individual, that you've informed them, look, if something happens to me, I want you to do such and such, so then they would be able to make sure that gets carried out on your behalf. And the next one is a living will. That's similar to go to a power of attorney, but a living will is a document that outlines an individual's preferences for medical treatment and interventions in case they become unable to communicate their wishes due to incapacitation, particularly in critical or end-of-life situations. That could be something where it's like if you're no longer able to physically function and your brain, you become, some form of issue with your brain, or you're just in the hospital, just completely unable to do anything, and there's going to be no progression. You can kind of make the decisions, and I know these are tough decisions, but you'd be able to make the decisions of what would happen to you at that point in time. And you can then, you can also implement, Islamic laws in there, and just kind of procedures to make sure that you're protected and that those get carried out to your wishes. And I know Hamza earlier mentioned something along those lines, and that could be, for those brothers that may have, if had they had a living will, they would have been able to protect themselves as to what happens with them after they pass. And then the appointment of guardianships, just like I said, if something happens to you and your spouse, what happens to your young children, or if you're, the only remaining parent to your kids, who's going to take care of them? And so guardianship helps create that. Additionally, sometimes one thing to think about is if you're also potentially in an immigration process or something, and or you're in deportation proceedings or something along those lines, you may want to consider a guardianship just to make sure that if they end up potentially deporting you or something happens to something happens to you throughout the immigration process, then you create this guardianship and someone is trusted until they can take care of your kids while they're still here. So in conclusion, an estate plan is essential for protecting your assets and ensuring a smooth transition of wealth. It basically involves how your assets should be distributed, appointing guardians for minor children, implementing strategies to minimize probate delays and taxes, because if you don't have a plan, then what happens is you have to go through court, and that means there are specific statutory requirements. I mean, you're talking about multiple years potentially. I have a relative that passed away 2 years ago, and his estate is still not complete yet because of the fact that he did not have a will. So now his family is still waiting on that property that had to go through probate. And so by having a will, it kind of simplifies that process for you, and it protects your family from those delays. And like we mentioned, the living wills, they help you express like medical preferences. And then the main thing, the important thing is the estate plan helps you. It offers you peace of mind. It safeguards for your loved ones and ensures that one's wishes are honored. And I would strongly suggest consulting from a legal professional to make sure that they tailor the plan to your needs. Whether it's me or whoever else in the community, there's plenty of estate attorneys out here that will be more than happy to assist and make sure that your wishes are carried out. And so, again, I'm Hishem Alsalman, I'm the Alsalman office. Just as a brief reference, so we do estate planning, we handle a lot of immigration process issues. We deal with a lot of USCIS, immigration court. We've worked with, asylum cases, marriage petitions, fiancé visas, a lot of anything in immigration, you name it. We also assist with civil litigation issues. If you wrongfully get sued or someone, you paid for a specific service and it didn't get carried out, we're able to assist with that. We also help you with setting up some form of business or drafting out contracts, as well as if you're involved in a car accident or some form of personal injury, you can reach out to us and we're able to assist you. Now, these are just some of my sources. And now I want to open up the floor to just kind of have, see if you guys have any questions and be able to answer those. So, yeah.
So, this question, I'm kind of asking from the perspective of a lot of converts. From what you've explained, let's say somebody converts to Islam, they want to ensure that they're given the ghusl made, salat al-janazah, so on. And maybe I misunderstood. It appears like a living will would be the document to ensure that?
So a living will works while you're still living.
Gotcha.
When you pass away, your will can designate, this is the process that I want to be buried in, this is how I want it to be carried out, and that's the way to protect it, is by putting it in the will.
Now, when they file this will, do they have to take care of everything, including breakdown of inheritance requests, or could they specifically file that portion on burial, debts, and then maybe in the future return to other details of that last will? Does that make sense?
Yeah, so you can kind of make it as simple as you want it and designate maybe one beneficiary of your will, and then one person, and the beneficiary, that person that's getting everything in your estate, can also be the executor, who is the one that administers your estate, and they can also be the one that is able to assist with your burial and take care of everything. And you can, here's the thing, you can make it as complex as you want it, or you can make it as simple as possible. There's people that have created wills where it's, I want to give everything to my wife, and I know she's going to be able to take care of everything, take care of our kids, and so on and so forth. I want to give everything to my husband. A lot of times married couples do that, or if they're single, they'll may designate a specific sibling or a best friend or someone that can assist them. But yeah, you can put your burial arrangements in there. You can say, I want to be buried. This is the process that I want it to happen, and this is exactly how it should be carried out. Because if someone, the law will be very, very, there will be, you have to carry it out exactly according to that will. And when you say file, so you don't actually necessarily have to file a will, you just need to have the most recent original will. And that's where, like I said, sometimes you can create multiple different original copies of it. And a court will make sure that that's, valid. Do we have any other questions at all? All right, well, I'll be here. Thank you all very much. I want to thank Tomas for, having me. Thank Hamza for helping me get it. And feel free to reach out. Like I said, this is my contact information. There's some business cards up here. I'll be up here if you guys have any questions. Feel free to reach out to us. All right, thank you.